welcome Linda Gallagher from MRSC. She is giving us a presentation on the characteristics of effective and ethical public service. Let's see, Linda has been with MRSC since 2017. She previously served as a senior deputy prosecuting attorney for King County and as an assistant attorney general. She graduated from St. Martin's University and UW School of Law. Linda is a certified mediator as well. Her municipal law experience includes conflict resolution, government, risk management, courts, civil rights, transit, employment, workers' compensation, eminent domain, vehicle licensing, law enforcement, corrections, and public health.
Wow,
Lots of experience and expertise. So maybe some other future presentations, but we are here for you. We are looking forward to today's presentation and
thank you,
And
Lori. Thank you. Welcome, good afternoon. I'm Linda Gallagher, and I am so pleased to be here to talk with you and present about effective and ethical public service. First, I just want to say, you probably know this already, but it's really a journey. It's not a destination, or it's not a, okay, in the next hour and 20 minutes, then we'll all be the most effective and ethical we can be. But I have a lot of information for you and I'm happy to share it today. First, here's my picture. We'll go through past that one quick. I don't have a clicker.
maybe, I don't know if I do either. Oh, there we go.
Next slide. Before we start, this slide is about MRSC services. That's where I work. It stands for Municipal Research Services Center. And I always say that at the beginning of a talk because sometimes I get to the very end and someone's question is, what does MRSC stand for? So Municipal Research Services Center. This slide shows our services. You're probably mostly familiar with them. We have free or prepaid consultation, one-on-one consulting. I think that's one of the coolest things we do. You can call us on the phone, or you can fill out a form on our website, mrsc.org, and we will do some research and get you some guidance about your question. We'll probably also say we recommend you consult with your agency's attorneys, but we have a lot of resources for you. So who here has used either called us, emailed us, or filled out an Ask MRSC form? Okay, a few of you, maybe 6 or 8. If you have already done that, who would do it again when you have another question? Great, and if you haven't contacted us yet, I welcome you to do so. Our website has a lot of depth as well, more than 300 topic pages, all kinds of municipal law, procurement, finance topics there. And we do our best to be a neutral, accurate source for people. And it's in municipal service. So let's see. There are other things that we do as well. Let's go to the next slide though. This is our legal disclaimer. I am a lawyer, but I'm not your lawyer. I'm one of 6 legal consultants who are lawyers at MRSC, and we provide legal guidance, not legal advice. So that's the distinction we make. So we're not in an attorney-client relationship with you. So legalese, but this is our formal disclaimer you'll see on our website, and also when we send you an email. But I'm not going to read it all, so you can read it at your leisure. Also, I want to just shout out to whoever's online in the hybrid meeting. If you're on Zoom, you have a question for us, a comment, just put it in the chat. Corey will probably see it at some point, and we'll try to get to that in this presentation. But we're glad you're here too. So next we have our agenda for the day. So ask questions as we go along, but I've included a number of slides that we may not have time to cover in detail, but I wanted to provide them as a refresher, especially the ones about open government, the Public Records Act, PRA, and the Open Public Meetings Act, OPMA. MRSC has all-day Public Records Act workshops that you're welcome to sign up for and attend. They're very well received. We have periodic webinars with deep dives into different aspects of open government ethics and also building trust. So we're going to talk about first, what is a public servant? Why do we still use that phrase? What does it mean? And then effective. And here I always find a typo when I present. So here I found that I wrote effective and effective. I left ethical out. How ironic. So I think I was reversing the order and trying to put ethical first in the agenda. But anyway, we're going to talk about ethical and effective characteristics of people in public service. Second, we're going to talk about ethics and conflicts of interest. There's a state law code of ethics for municipal officers you probably know about. And then third, open government refresher, what's new in the OPMA, the PRA, and also focus on privacy for public employees. And then fourth, or my third on this slide, prohibitions on gifts of public funds and financial accountability. I have a little bit in here about those two things because they're very important, and there's other places to go look for more. Then I'll try to leave at least 10 minutes for questions and answers at the end, but throw them out now too if you'd like. So next slide, please. Public servant means. So I found the definitions in dictionaries: a person holding a government office or job by election or appointment, or a person in public service. So this covers both officials and employees or staff. So public employee, government worker, civil servant, civil service, elected or appointed. Public servant is kind of an umbrella for all of that. Public servants or persons in public service, which is probably maybe a better or more modern phrase to use, although it's longer, serve their government and also serve the public. Now, I looked a little more on what public servant means, and I agree that that's what we're talking about, but it's a little bit outdated now, I think, because the word servant comes from the old English common law of master and servant, which is primarily about employers and employees or principal agent, you know, when employers are liable for what their employees do, even if it's not public, it's private employers too. But master and servant also has some maybe outdated negative connotations, especially the word master. Like in real estate TV shows, they don't even say this is the master suite now, it's the primary suite, because some of these words maybe could be retired because of their connection with maybe indentured servitude or indentured servants, or also masters of enslaved persons or indentured persons. So I'll try to talk more about persons in public service. I just thought I'd throw that out there for you at the beginning of the talk. Let's stay in history and colonial times. So this is the line from George Washington to Alexander Hamilton, at least in that musical Hamilton. Winning is easy, young person, governing is harder. Now I put person in there because it said young man, and I was thinking, oh, I should make it gender neutral. But then I realized I left young there, which leaves us older people out as well. So it would have been better to edit young man completely out, because the point is winning is easy, governing is harder. And this is good for now too. It's easy to win an election or win a war back in the revolutionary times, but it's difficult to govern and to make the hard decisions and do your best for the people and for your agency. Next slide. Let's now turn to the title of the program, or the meat of it, or the basics: effective and ethical characteristics in public service. So in my job interview for my current job, so a little more than 5 years ago, I was asked to give just 2 words that my supervisors in my jobs before would use to describe me and what kind of public employee I am. That's a hard interview question, especially for a lawyer, because we use a lot of words and we try to make things complicated. We don't use one-word sentences very often, at least in my experience. So thought about it. I was quiet for a bit, which I'm not usually. And then I came up with 2 words that I think are also characteristics of good public employees, and that's honest and kind, because I really am honest and kind in everything I do, personal and professional. There are 2 things that are core to who I am and what I do. Even back when I was an enthusiastic and competitive trial attorney on behalf of the state and then on behalf of the county, you can always keep these core values or characteristics true. So let's go. We already have this one, so let's stay on this slide. We'll back up.
Oh, sorry.
No, I was going to get a little interactive. So besides these 2 characteristics, how about just one word, throw it out there. What other characteristics do you think are important to public service?
Integrity.
Integrity, great. And I love hearing integrity and honesty toward the end of the last presentation, because that kind of circled to here. Integrity, what else?
Diligence.
Diligence, yes, how we do the job. How we stick with it.
Responsible.
Responsible, yes.
Accountable.
Accountable.
Efficient.
Efficient. Okay, slow down just a minute. I'm gonna misspell one of these, but not, I don't think I have yet, but call me out if I do. Oh,
Yeah, you did.
it's that manifestation thing that's a different class. Efficient, what else?
Transparent.
Transparent, yes. Consistent. Give me 3 or 4 more, well, then we'll move forward.
Patient.
Patient, thank you.
Risky.
Risky, oh, I like that one. That's like brave, and yeah, okay, what else?
Thrifty.
Was it thrifty?
Yeah.
Oh, thank you, thrifty. Thrifty. If you're online, do you have any? Any other ones you're burning to shout out?
Respectful.
Respectful. Thank you. Okay. Let's go to the next slide.
Inclusive
Oh,
from
inclusive.
online, yep.
Thank you.
Mhm.
Great. Don't go to the, or go to it now, I don't know. The next slide, I wrote down a number of them. There's, it's not an exhaustive list, but a lot of these are on this list as well. We didn't flash it for you, but it's not long. So honest, kind, accountable, reliable, authentic, curious, transparent, trustworthy, competent, understanding, hardworking, learning, brave, neutral. Anyone think anything should come off either list?
Yeah, it seems like those touch on the ethical part, but not so much the effective part.
Right, the question is, these seem to be more focused on the ethical part, but not the effective part.
As much anyway.
Fair comment, fair comment. The, maybe hardworking is,
Right.
unless you're doing more than you need to, or, and some of the ones here too with, well, let's see. Efficient for sure, consistent, accountable.
Understanding.
responsible. But yes, there's a lot of overlap and those 2 words are different things. Good point.
I'm a financial person, so I'm always thinking of saving money.
So numbers, and I was a math major in college, so I like the numbers. It's important. And transparency about funds is really important too. So you can make sure that you and your team or your organization are handling the money right, and that the appearance of handling it right is there too. No, great comment. Let's go to. I have a slide about trust next. What is trust? And trust comes under like trustworthy is one that I had down. And this is a slide. It's one of my favorite ones from a building and repairing trust at work webinar that Amy Leneker presented to us. She's a great leadership consultant in Olympia. I would recommend her to you. And she got this slide from the Center for Creative Leadership, so CCL, and that's it's online, has an online presence, a global nonprofit provider of leadership development with headquarters in North Carolina. This slide is about how the 3 things of character, competence, and communication all fit together. And at the sweet spot in the middle where the Venn diagram comes together, that's where you have trust at work and you can count on the other person. So I can communicate really well, I can be a good cheerleader, and I can have good character, but I need to also have the competence and the drive and the effectiveness to be able to get my projects or my pieces of work done when I say I will, or when they need to be done. And so all of that overlaps and comes in the middle here. So now there are 4 books that I want to recommend for resources, not really homework, but if you want to dig deeper in some of these things. First is the 2018 Brene Brown book, Dare to Lead. And then she has a newer book called Atlas of the Heart, Mapping Meaningful Connection in the Language of Human Experience. That works both personal life and work life, of course. And that's in 2021. And I got all 4 of these on a slide, but I put the pictures in first. The next one, this is older. This is Morris Rosenberg, Nonviolent Communication, The Language of Life. Great book, resource for how we communicate, how we listen to others, and how we learn what styles others are presenting in and how to best understand them. Then next is Crucial Conversations, and that's about tools for talking when stakes are high. That happens often in public service. And that one is, I think, 2003 or 2002, and then we have the trustee older 7 Habits of Highly Effective People, which I don't know, it's 1989, so many people weren't born yet, but I finished law school in 1986, and I really latched onto that book, especially the part about seek first to understand and then to be understood. So you're listening and understanding who you're working with or who you're dealing with. The next slide is just the list of all 4 of the books. I don't know if you have access to a copy of this, or if you want a copy of the slides, let us know after. I'm sure Corey or I can both send them to you, and my contact information will give out as well. Next slide. Let's turn now to ethics and conflicts of interest in the law. Local governments may adopt their own codes of ethics, but state law also provides an ethics code. The state law is the minimum, and it has a provision that says the local government may adopt more restrictive or higher level of ethics than the state code. Next slide. So state law, its code is in chapter 42.23 RCW. It's the Washington State Code of Ethics for Municipal Officials or Officers. The core of the statute is 42.23.030, and we summarize it here. No municipal officer shall be beneficially interested, directly or indirectly, in any contract which may be made under the supervision of such officer. So let's break it down a little bit. In the next few slides, we'll discuss the questions first. Who is a municipal officer? That's almost everyone. Spoiler alert. And then also, what are interests? What's a beneficial interest? What does it mean to be direct or an indirect? What is a contract? Which should be really easy, right? And also, what does it mean to accept compensation or a gratuity or reward in connection with a contract? Now that one's easy because that means a bribe basically, or some influence you, someone maybe like vendor at a conference or something, you know, wants you to always hire them, not someone else in the procurement fairness process. So they're going to give you a dinner, or I don't know, think concert tickets or Seahawk game tickets. So next slide. Nope, one back, sorry. Who is a municipal officer? Now, next slide, thanks. Not quite getting the mind. Elected and appointed officers, deputies and assistants, and then persons exercising powers or functions. Most municipal staff are included under the state law definition because it also includes all deputies and assistants of the municipal officer. So definitely elected officials and senior staff are covered. Gets a bit murky when you look at employees farther down the chain. It's good to, I think, just assume that they'll all be considered unless if there's a close call. But in general, MRSC, we tend to try to give the conservative response about how to make sure they're not even getting close to the line. So the next slide has further information about who is a municipal officer. There's a criminal statute that defines this term because it's not defined very clearly in the civil statute. So persons holding office who perform a public function, exercising sovereign power of government, and assistants, deputies, clerks, and employees. So now that we know who we can focus on what. Is there a contract interest? Now, RCW 42.23.020 sub 3 defines a contract as contract, sale, lease, or purchase. But to quote Captain Jack Sparrow, I should have a picture of him, but I don't. That is just maddeningly unhelpful. That is just maddeningly unhelpful. And that's because that provision violates one of the basic rules of language. The legislature defined a word using the same word. Defines a contract as a contract. And then lists several types of contracts, so that's somewhat helpful, sale, lease, or purchase, but it's not very helpful overall. The Washington courts have explained that the code is mainly directed at self-dealing. The intent of that section of the code is to keep a municipal officer from being on both sides of a financial transaction. So in essence, writing government checks to government officials other than paychecks is what's involved, and you just don't want to be on both sides of that process, either you personally or your staff or your supervisors or those you work with at the agency. So in its broadest sense, this statute, a contract is an exchange, usually of money for services. municipalities buy and sell goods, property and services. But now we have some slides that talk about other contracts interests. Next slide. Examples of non-contract interests. So these are ones that the courts have held are not contract interests under this rule. So voting to hire a lawyer, say a supervisor on your board, voting to hire a lawyer to represent and indemnify the board. It's okay if you can't vote to hire yourself as the lawyer, but it's okay if there's some direct or indirect connection with who you hire. There's a, the board itself is making that choice. Ownership of a tow company, that's a city case where a city council member can own a tow company where the law enforcement police call the tows out when they have a disabled vehicle and you can still be in that rotation. Unpaid board members of a nonprofit. Many people in public service also have volunteer work they do or do work for nonprofits as well. If you're an unpaid board member of the nonprofit, the agency where you also work can contract in general with your nonprofit. Question in the back. Sorry that you had it very long.
No, sorry.
No, please.
A fair amount in the consulting world is commenting on the language of an RFP and then also applying for that RFP. Which side of the edge is that land on?
Interesting. You said commenting on the language of an RFP?
Yeah, like supporting the development of an RFP, but also then being one of the people applying.
So supporting the development of it, either with your agency or with the awarding, like grant agency? I'm not
Yeah.
quite,
So like, you go to like the example that can be like, there's a person who's an expert in a field.
yes,
And so they're called on to like ask what should be included in the call for proposals, like what criteria or what, and then they're also either helping others apply for that funding or applying for it themselves.
or applying it for themselves or helping others apply for a grant when you've already participated in the development of the proposal, the RFP. I don't know, and that's going to be my answer to some questions, but I hope you'll still ask questions. I don't know for sure, but, and it probably depends, those are lawyer phrases too, but I think if you have the inside information in helping develop it, then that might give you an unfair advantage in applying for it. And here's a comment here, I hope it helps us.
When I call public works contracts, I'm always reaching out to different factors to understand what estimate is. So I feel like it's the same situation as that, and then I check with legal and so they will do that. We gotta be
Great, great. And to repeat her comment, she said in the process of public works or small public works procurement, she's checked before with some of the contractors she knows about what should be in the request. And that even though she's checked with them, they still can apply. Makes sense. They're not employees of the agency, so that might be a difference, but, and these questions are pretty specific. And you're welcome to ask us the question, one of the 6 of us through our website or with a phone call as well. We can help more with that. So flagging that issue that in your question, I think is important to think about that. Like if you're going to learn something that no one else knows, but it's going to make you for sure the winner of the grant. Maybe not. Yes.
But they have to publish what the criteria is, so everybody would see that criteria, so, I mean, even the person who wrote it, they wouldn't really have an advantage.
That's a good point. So if they publish the criteria, then what other advantage could there be? And I don't know, unless there's something that got held out from it or something.
Unless in the selection committee, they're already kind of like, we like them because they helped us, that would be.
Maybe, yeah, that could be an advantage. And great question to highlight. These are not always easy questions. And the courts get involved pretty often.
And I think our language explicitly says you cannot do that. Cannot see if I put somebody in them.
So and what agency are you at?
There's conservation district.
So Thurston Conservation District, maybe it's a local policy or it's an interpretation of the state law that if you provide advice for what the grant is going to be or what the project is, then you don't apply for it. So good to know. So next slide. There's some exceptions in the statute. This is in 030 as well, but they're limited. So we encourage you to discuss any of these situations with your legal counsel, but in summary, a municipal officer may also be a customer of the municipal utilities. That's the utilities one. You can work at public depositories of municipal funds. So maybe if you're a bank teller or something like that, or the newspaper, you work at the newspaper for legal notices, provided that the rates are not special just because someone at your agency works there. And all of these assume the municipality or the officer pays the same prices as the general public for what they do. There's also an exception for real small contracts that just, there's legislation this year that it's $1,500 a month right now, but it's changing to $3,000 a month, but it's only for, I think just small cities, less than 5,000 population, but it might also be for some special purpose districts. So let's go to remote interests. Let's see, up here. Remote, just my notes, sorry. Non-salaried officers of a nonprofit corporation, we mentioned that one already. An employee or agent who's paid fixed wages, your wages aren't going to change if your agency gets the grant, like for the IT project or for something else from a municipality. Landlord or tenant, and then a holder of less than 1% of shares of a corporation. Say you have Microsoft stock, that doesn't mean your agency, if you're on a supervisor on the board, that doesn't mean your agency cannot do any work with Microsoft, because unless you own more than 1% of Microsoft, then you might not be on that board, but maybe you would. So those are some of the remote interests that it's okay to have under this act. Now, know when to pause and ask for help, and this is back to the, check in with your lawyer, check in with those at your agency that have more experience with this. Look at your local policies if you have them. So we have Danger Will Robinson, which is a Lost in Space, a TV show on CBS that was off the air by 1968. Thought I'd share that for historical.
Netflix redid it a few years ago.
Did they? Netflix redid it. See, there we go. I didn't know that. Thank you. Next slide. Penalties. The Danger Will Robinson. There are penalties in the Code of Ethics for municipal officers. A contract is void if it's made in violation of that, found to have been made in violation of that code. Usually that would be with the court. A $500 fine can be imposed personally on the members of the governing body or the person that violates it. And then an elected person can forfeit their office. But those are all things that would be part of litigation about this. And there's very little experience where things go quite that far. So moving on to the question of whether there is a contract interest. Special privileges is in 42-23-070. And I'm just going to briefly mention this, but the Attorney General's office has interpreted this to mean a special privilege is one that you're not legally entitled to. So it involves being allowed to do something that would otherwise be prohibited. So you can tell a family member or tell someone about a job opportunity or apply for a job opportunity that you know of just through your public work, because you're not getting something that you're not allowed to have. Based on your employment. A special exemption involves being relieved from doing something that would be otherwise mandated. Special privilege involves being allowed to do something that would otherwise be prohibited. So let's see, there's an example. I think I have one example. City council members who are unpaid board members of a nonprofit voting or on funding for the nonprofit, they're not securing a special privilege to the nonprofit because the full council votes, it's the city making that grant. And I think there's other examples that could be found definitely in boards of grants as well. Let's turn to the next slide, prohibited acts. There's also 4 different things that are, or 3 different things spelled out. You're not allowed to disclose confidential information, outside employment or activities. There may be a limit on that depending on the RCW. And then also giving or receiving compensation, a gift, a reward, or a gratuity, or a tip or something. The state law has a de minimis amount, I think, of $50. Local government doesn't have a de minimis minimum amount. So you really can't take a gift if it's in connection with or because of your service for your municipality. So that's, again, you think drawings at a conference like football tickets or iPads. And then confidentiality is important, obviously, with things maybe said in executive session at a board meeting. So now let's turn to open government and what's new with the OPMA and the PRA. We're talking about privacy and what's new. So this slide's where I want to, yes, OPMA, Open Public Meetings Act. It's the intent of the chapter, and I'm going to read it because it's interesting, both because there's a new amendment in 2022 that I underlined, and because of the language they use. So the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and what is not good for them to know. The people insist on remaining informed, and then here's the amendment underlined there, but and informing the people's public servants, here's that phrase again, just recently, of their views, so that they may retain control over the instruments they have created. Basically, all government, including local government, created by the people. And in 1972, we got the Sunshine Laws that have the OPMA and the Public Records Act. So, and this addition was made in 2022, when the legislature said that public comment is now required in your regular meetings when final action will be taken. So the basic, next slide is the basic requirements. All the meetings of the governing body shall be open to the public and people are allowed to attend. This was difficult during the pandemic because there had to be pivot to remote only meetings. Now there's some hybrid only meetings, and there's a little bit of changes in the law here, but let's move through to the next slides. The OPMA does not apply to certain kinds of meetings that are called closed meetings. They're not executive sessions. So we list them here: quasi-judicial, which might be like land use zoning or land use permit applications, collective bargaining, labor negotiations. Does not have to be a public meeting. In fact, you cannot insist that it be in an open public meeting based on a recent court case where the government, several cities wanted to say, no, all our labor negotiations going to happen in front of the public. That's it. The court said, no, that's an unfair labor practice. You can't require that. You have to negotiate how your negotiations are going to happen. So certain licensing procedures like business license, and then Administrative Procedures Act proceedings. Next slide. What is a governing body? I'm going to leave that with you in the materials, but it's basically any legislative body, including district supervisors boards, that do the legislation of a public agency. And then also committees and subcommittees if they're created by the legislative body, and advisory bodies. And then these next slides, they're a little different background, but these are great slides that I borrowed from Morgan Damerow at the Attorney General's office at a presentation we did last year at AWC. But so we have definition of what it means to be a meeting and taking action. If you have a quorum and you're taking any action and it's defined broadly, you're in a meeting. If there's no quorum of your board members, there's no meeting. Physical presence is not required, and a meeting can happen over the phone or email or turn into a meeting. The OPMA, though, still requires that you have some kind of in-person option for people to attend your meeting, but you can also have a remote option. It doesn't need to be called a meeting. People have retreats, workshops, study sessions. Don't be fooled, it's still a meeting under the OPMA, so you need those notice to follow those requirements. Yes, question?
Can you tell me a little bit more about email? That to me doesn't seem logical that use of email can actually be used as a meeting. How's that?
Great question, and I have an example. So, but let me repeat the question first for the recording. Can you say more about email? How can emails be a meeting? It doesn't seem like something that would be a meeting. And I talk about emails between or among the members of the governing body. So here it will be the supervisors on the district's board. If you have an email, you can give information to everybody, but if it becomes interactive or you reply all and say, oh yeah, that's a great idea, I'm going to vote for that, or anything that meets the definition of taking action, that can sort of accidentally become a meeting that's illegal because there's no members of the public on that email chain. The city of Seattle had that problem a couple of years ago when they were doing something about taxing, they called it the head tax at first, but taxing employees of high earning employees. And then they decided to undo it really quickly. And they had all these, they did it by email. They didn't have their meeting to do it until it was all completely decided. So it's called a serial meeting. If you have by email collecting maybe your votes or back and forth, just basically when when you want to send something, one supervisor or board member to the others, often you can ask the clerk to send it out to everyone. I want everyone to have this information before our next, on purpose meeting. But if you send it out yourself and if people reply all, even if you've said don't reply all, then it could be deemed an improper meeting under a violation under the OPMA. Does that make sense?
That makes sense. I guess I was reading that quote or that line as, this is a forum by which you can have a meeting.
Exactly, yes.
Not-
Right, no, yeah. By accident, yeah, you can have meetings by accident, but not on purpose. It wouldn't, you're right, it would not comply with the OPMA to do a meeting with email. Question or comment?
If you, as the, say, district manager, send out the ECC, your board, and ask them a question, and they only respond to you, and they're not making a decision, it's just say, I don't know, how would you feel about X, whatever, something, and they only respond to you, is that okay?
Maybe. The question is, if you as a district manager send out an email to your board members, but you're BCCing them, blind carbon copy, or in a way that they can't copy to each other, but inviting them to tell you how they feel about something, is that okay? It might not always be, because if you're like counting up, I mean, you can always do it for scheduling a meeting or setting up a meeting. But if it's about a subject of some business of the district, even if they're not taking final action, action is defined so broadly as discussing, considering, etc. It might be safer to check in with them one by one, which is not that logical because it seems like the same thing of what you're saying. So maybe you can do that, but be careful what the subject is. Not very satisfying, but better than it depends. I don't know.
I guess it would only be a forum if they can
Respond to each other.
respond to each other or like, witness each other's.
Right, and consider each other's, thoughts and stuff, yeah, or deciding it, or like sort of deciding it. So most of, what the board does really needs to happen in their open meetings. I get questions often about, well, how do we get anything done if we have to wait till our meeting? It's like, the whole point is you get things done as a board member, a supervisor, or a council member in your meeting. Wait till then to get the things done with each other, because the public has the right to watch you do it. And also now to give you public comment while you're doing it. So, yes.
Question then, what if you're looking for opinion, like whether or not they feel a certain funding source meets your mission? Like, does that still, if it's just an opinion, you're not asking for a decision?
It depends on what if you're looking, the question is, what if you're looking for an opinion, like is a certain funding source, something you think would work for something? If you're looking for the opinion of an individual member of your board, it's okay, I think. But if you're looking for the opinion of the board or as your agency,
Then that would be.
I don't think you should do that, yeah, because that could be a kind of a meeting. It's sort of a, I don't know, slippery slope or something like that, and
Better to just include it on the agenda.
don't want to get too specific, but better to do it at the meeting if you're looking for what your board is going to do. And because the two people on a 5-person board that maybe aren't usually in the majority, they're going to be, oh, they did it again. They decided without us, have it happen at your meetings. That's what the meetings are for too. But you still have to get your work done. Yeah. Okay, let's move on from this because I have a lot more interesting slides for you. And the next slide, let's see, action. Oh, speaking of, action is defined so broadly that it's almost everything. Public testimony, discussions, reviews, also final action, but that's requirements are triggered whether or not it's final action. That's why final action is on this list. All deliberations, all considerations, all evaluations. Let's go to the next slide, final action. Final action is a collective positive or negative decision by the board or an actual vote by a majority of the governing body or by the committee of the body. So that's when they make a decision. It must be taken in public, even if deliberations were in a closed session. So if you're like approving your collective bargaining agreement with union employees, you can talk about it in a closed session. You're not required to be open session, but when you make the decision to approve the contract, that's in the open meeting, for example. Secret ballots are not allowed. Secret ballots are not allowed. You're filling a vacancy, you're hiring someone, you're doing something where you don't want to hurt other people's feelings. So can't we just write it down on paper and let the manager or the clerk, count it up? No, you can't do that. There's some argument that you could read the papers out loud and filled out each one, but then why do that? Do it out loud in front of your public and your colleagues. So public attendance, there are two new parts of the law here. They're from 2022, so it's a year old now. But you can't place conditions on the public attending your meetings, your public meetings. You can't have reasonable rules of conduct. The public can record your meeting. It's not a private thing. It's already public. Many people record their own, agencies record their meetings as well. But they can't be disruptive, so they can't be like up in your face with a camera or getting in the way or blocking you from seeing things, that kind of thing. So the two new parts of the law are, you may adopt conditions to determine, let's see, generally applicable conditions determined to be reasonably necessary to protect public health or safety and to protect against interruptions. So this is like if there's another flu thing or something, and the masks come back out at the public meetings or something like that. You can have some orderly rules of conduct. And now the second one here I like more. Agencies are encouraged to provide remote access that does not require an additional cost to access the meeting. Hence Zoom, for example. But agencies encouraged is a strange thing a little bit to put in the law. And I think it was a compromise, perhaps. We don't follow legislation. We usually at MRSC see it after it's passed. But encouraged to provide remote access might be a hint that more than encouraged is coming down the road. So next slide.
Question for you.
Yes, thank you.
The second to last bullet, when it comes to generally applicable conditions for public safety, would weather for that?
Weather could,
If there's snow on the roads and traveling.
weather could count if it's extreme weather. In some parts of our state, snow is more extreme than in other parts, or depending on how much comes down. But yes, weather could be one of those things where you can maybe pivot to remote. The board would need to make some kind of finding if there's not a statewide order. And their statewide order is why during the pandemic, all the meetings had to be remote. But this new law gives more discretion to the agencies to take those kind of actions. You could do that, but work with your lawyer to do it. Question here.
Yeah, I had a question on the last bullet about encourage. You said that in the future it could be a little bit smaller than that. I'll just give you the example. Since COVID, we, in order to be more inclusive and to provide better access, we have had Zoom, a hybrid option on all of our board meetings.
Nice.
Except sometimes we have a tour.
A what?
It's a tour, like
Oh.
we're gonna go out in the field and look at some sites.
Yes.
It's still a board meeting, but we're not providing that remote access.
Right.
I mean, so as it's written, that would be okay, because
Yes, as long as you allow the public to join your tour in person when you're having a tour. With a quorum of your board members, because even though they're walking along, it's a meeting, they're doing business. What they're seeing is about your agency's business and what they're saying, unless you tell them not to talk. But maybe in the future,
person only.
that's a really good point, because maybe in the future, if there are tours, like at a port or a city or wherever, you might have to have someone be I got my selfie stick with the Zoom meeting, bringing in all of our remote people. I mean, I don't know how many people are doing that, but great question.
But for now, as long as you provide in-person access.
Yes.
Even in-person only, that is still acceptable.
Yes, the remote options are encouraged. Many people are doing it. They're finding it's way more easy than we thought it would be. Back at the beginning of the pandemic, it's no, we can't do remote meetings. It's too expensive. We don't have the right equipment. And then people figured out, okay, we can do it because everything's that way. So we have to learn. Question.
So also the second to the one where it talks about recognize interruptions. So, does that mean that the board can take people out if they were being disrupted?
Maybe, probably not, unless they're disrupting your whole meeting. Then you may be able to ask someone to leave, or you can stop your meeting and adjourn it to a later time or a different place. And there's some provisions already in the OPMA about that, but there's one new one that we're gonna get to too. But disruptions, it might be a little more tools to handle it, or handle it with the tools that are already in the OPMA. So next is, oh wait, go ahead.
Before we get too far afield, I was under the understanding that you could have like a workshop or that type of thing, as long as you advertise ahead of time that the board members will be present, a quorum will be present, but no decisions will be made at this workshop. Is that okay?
The question is, can you say, have a workshop and say the quorum of the board members will be present, but no decisions will be made? I think that's my experience, that danger Will Robinson, but my experience is that when you go to a conference, like say all your board members are here and they're gonna go to this, and you might want abundance of caution, give notice, but say they're not gonna do any of the district's business, they're gonna learn, they're gonna be forward facing and hearing what we tell them. They're not gonna, at dinner, go do the big deal that everyone's been waiting for them to do. But if it's a workshop of a quorum of your board members, the public needs to be allowed to come in general, because of the OPMA. Does that make sense?
To a certain degree, yeah.
Okay, good. Well, check with us later. I'd welcome email or call about that and do some research for you. When we do research at MRSC, it's usually 1 or 2 hours of digging in on previous inquiry responses, so it's fact specific. Okay, remote observation. Agencies are encouraged to provide remote access. Again, this is encouraged but not required yet. I think that word's an interesting choice. I like that it's in there. Things are going to evolve. But if I had to guess, and who knows what's in a legislator's head or the legislature as a whole, maybe not next year, but I think soon coming, there'll be maybe a remote requirement. The tricky part though is what about being all remote? And that's still not allowed unless your agency declares an emergency or the state has declared an emergency. So let's go further. If you want to read more about this or more OPMA, we're gonna keep going first. Written public comment or oral comment. So oral or written public comment is now required prior to taking final action at a regular meeting, not a special meeting. So I think that's a compromise, but at your regular meetings, you either need to allow public comment, and we recommend you do it at the beginning because it's before final action, and even approving an agenda really is final action. So you can take oral comment, or instead you can allow written comment far enough in advance of the meeting and then distribute it to the members so it can be considered. So that's the public comment thing. That's probably the biggest change in the OPMA in the last year. And the law says, except in emergency situations. So which emergencies are they talking about? Declared or natural ones? Not sure. But let's see, the next section is regular meetings. The thing that's new there is very small agencies may now be the only group that's exempt from posting your agendas online. Because now there's a provision where you can share, get posted maybe on the county's website or something like that. More agencies need to post their agendas online for regular meetings. Special meetings. There's a special exception. You're not required to put notice at the place when notice cannot be posted with reasonable safety. That would go to maybe the big snow event or another kind of emergency, or if there's a pandemic again. You don't have to put it on the door of the physical meeting for your special meeting if it's happening somewhere else. And then the last thing here is prominently display at the main entrance of the agency's principal location and the meeting site if it's not at the same location or not remote. With that exception though, those two seem to contradict, sorry. And also include links and phone numbers for public attendance if you're having a remote portion of that meeting. Next slide, emergency meetings. This is like think volcano or fire or snow and whatnot. Notice is not required when a special meeting is called to deal with an emergency, if it truly is an emergency. Yes, question.
Question back on special meetings.
Sure, let's go back.
You may have already said this, but can you define what a special meeting is?
Oh, yeah, I skipped over it. The question is, can you define what a special meeting is? A special meeting is basically not a regular meeting. It's a meeting of your board at a time and place that's not already set in your either bylaws or resolutions or, on your website. Our regular meetings are this first and third Tuesday of the month at 5:30 to 7 or something. Anything outside of your regular meeting is a special meeting. It needs at least 24 hours notice to have it. It's still a public meeting. You can only take final action on things that you put in the notice of the meeting. So that's where the city of Seattle got in trouble on that one recent thing where they tried to hurry and backpedal on something. And it's like, wait, you did that part wrong too.
And a follow-up question, just in this how it talks about like sending it out to the local newspaper. That's like an additional requirement for these as opposed to regular meetings.
Yes, regular meetings, you don't need to send out notice that you're having a regular meeting to the newspapers. But for a special meeting, if there are newspapers that have let you know, they want to know about your meetings, you send them a notice about the special meeting. That make sense? Okay,
So then it would be an interested party.
So
at that
what?
point. The newspaper or TV, whatever, has to be an interested party on file.
oh, the newspaper has to express interest in getting your meeting information. A lot of people probably have a list of that, but yeah. So emergencies. That's like, it involves, often it can involve injury or damage to persons or property, and time requirements of notice make notice impractical or impossible, or increase the likelihood of injury or damage. So it's rare to have an emergency meeting. If you're thinking we need to have an emergency meeting about this, definitely review it with your attorney and other leaders in your agency to see, is it really a true emergency that's gonna let us leave the public out of what we're gonna do? And then if we are, what are we gonna do and what can we save to do later at a regular or special meeting with notice? Okay, remote meetings, one more thing. Oh, in the event of an emergency, an agency can hold an all remote meeting, but the the board has to declare that it's an emergency. So that's gonna be rare, probably not as much in your experience, but
Does this apply to subcommittee meetings?
Good
So,
question.
Or committee meetings that aren't a full board, so. We have a situation in our agency where our subcommittee meetings are all remote. Does that apply because there's not a quorum because it's a subcommittee?
as long as there's not a quorum and it's a subcommittee without a quorum, then I don't think it would apply.
A subcommittee without a quorum.
Then it's, okay, it's, well, subcommittee or committee, yeah. But subcommittee, it might even both for a subcommittee or a committee, if it's less than a quorum of your
Of
supervisors.
the full board.
Of the full board,
Okay.
if it's less than a quorum of the full board, I think you're okay not having notice. It, or you can do it all remote. It might not be a public
But if-
meeting at all.
if, like, for some chance, a supervisor tuned in and there's all of a sudden a quorum.
Then you could be in trouble a little. You have to watch out for that happening. But check with your council and see. Sometimes council members or supervisors.
That's why subcommittee meetings potentially have been all remotely.
And you're right, and that's why they're set up that way, probably with less than a quorum, at least their membership, so.
Okay.
I think,
Thank you.
but double check, because
We will.
my guidance is general, even if it sounds specific. Okay, let's move forward, so I want to make sure we have time for questions. Executive sessions, the only interesting thing about that that's new is you need to, in your minutes now, enter into the minutes the purpose of an executive session. So just pick the one of the 14 requirements in the RCW that allows you to have an executive session, like buying or selling real estate when disclosing the amount that you might be willing to pay would adversely affect the transaction, etc. But 42.30.110 is the RCW for that. But in your minutes of your meeting, put in just which section. You don't have to describe it or tip your hand or disclose what happened. Like say it's discuss civil litigation with, our attorney. You don't even have to say discuss the Brown case and whether to settle it or not, because that could tip someone like, oh, I'm the Brown case, I'm gonna ask for more money. Okay. Minutes. Mainly that thing about executive session. Oh, and in 2023, the legislature changed the OPMA in 2 or 3 places, but it's only specific to school board meetings, not anybody else. So if you're on your school board or interested in your school board, they're required by a year from now to have audio recordings and they're public records, and requesters need to say which day they want for the recording, but then they get it in the Public Records Act. Yes.
For an executive session, if you say it's gonna end at 1:25 and the board ends it and comes out of executive session at 1:28. It was 3 minutes over, nobody extended it. Is that like a violation? I know it's not in.
Is it okay, let me rephrase, then I can think while I'm saying it. Is it a violation to come out of an executive session 3 minutes later than you announced in the public meeting you were going to come back without telling the people in the public that it's going to be extended some period of time, because you didn't know it was going to be 3 more minutes or 4.5 probably when you're in the executive session? Technically, probably, but with no consequence. I mean, ideally, you'd want to tell them right at 1:20, okay, stop just for a minute. I know you're not done, but what estimate should we go out and tell the public it's going to be longer? So yes and no, maybe 1 minute, I wouldn't worry, but 3 or 4 or 5 or 10, definitely go back and let them know, because people are waiting. And they want to make a decision of when I'm gonna go use the restroom, or, you know, what's going on in there. And it helps you be more transparent about something that you don't have to be transparent about the content.
Hypothetically, if there was no public waiting, would your answer change?
No, because someone might wander in, or maybe you've already wandered in and left in that 3 minutes because nothing's there and they don't know what's up, but maybe. Depends on how you're feeling. And the flip side of that one, what if you get done 10 minutes early from when you told the public? We said we'd be done at 1:25, but it's 1:15, we're done. Take that break of 10 minutes because someone may have left and come back. If there were no people at your meeting, do you hear it when the tree falls in the woods and no one's there? Back here.
So it says that the executive session's purpose must be recorded. If there's a final decision made, also the decision must be recorded, is that correct?
Okay, trick question a little bit, because it says for the executive session, the purpose of the session must be recorded. If there is also a final decision made, must that also be recorded? The final decision cannot be made in executive session. No final action is allowed in executive session. So if they're making a final decision or a vote on someone, or hire or not hire, or let someone go, or spend this much money on real estate, that has to happen back in the public meeting, and then it would get in your minutes. Does that make sense?
Yeah.
Or pass the budget, or I don't know. Okay, let's go. We have a slide all about interruptions. Someone asked about that here. The main new thing is you may stop individuals from speaking when they're not recognized to speak, like in public comment. Seems to go without saying, but that got added to the law, which is good because you have more control. It really is always your agency's meeting, not the member of the public's meeting. They're allowed to come to your public meeting, watch what you're doing, see what your agency is doing, but they don't get to speak when they're not recognized to speak, like at a public comment. Now, you can't boot people out though, unless there's no other way to restore the, I guess, the course of your meeting, or the piece of your meeting or something. But you can clear the room. This is already a law, but you're allowed to clear the room. The meeting can continue, or you can move to another location, but final disposition can only occur if you move the meeting on matters that are in the agenda. So if you're really interested in that, you can drill down or ask us questions later. At the beginning of Zoom, there were like some Zoom bombs. People would come into a meeting and just be completely disruptive, and it's some very offensive things, but that's trying to get at that a little bit too. Let's move on to the Public Records Act. I'm gonna breeze through this part in about 15 minutes, but you can still stop with questions or ask now about OPMA or anything else.
Quick question, on your previous slide, you said the number of participants participating remotely needs to be noted. Does that mean in your minutes, if you're listing all the guests at your meeting, previous slide?
No.
Yeah, it says number of remote participants, but you need to indicate each guest and if they're remote or in person.
No, definitely not. Let me see.
It's the last.
Yeah, if meeting-
Phone numbers and then number of remote participants.
Yeah, well. Oh. The links and phone numbers. You put it in the minutes, I guess, and then maybe the number, no, I just need maybe the number of participants. Links and phone numbers are how people call into the Zoom call. And then, sorry, these are my borrowed slides still from Morgan, which are great, but I'm not as familiar. But the number of remote participants, say it was between 20 and 43 in your little count on Zoom. Maybe put that in, but it's not required by law to put that in.
Thank you.
Yep,
We have the call-in info on our agenda.
great.
We also need to put it in our minutes.
I don't think so, but I don't know for sure.
I mean, we list our meeting ID, just to maybe tie it to the agenda.
It's nice to have it in there, I guess, to show that you actually did what you said you were gonna do in the agenda, but it's not expressly required by the Open Public Meeting Act. It might just be a best practice. But I could also be wrong. So if you're doing that, right, and you're thinking, oh, I should call Linda and ask her, or just send her an email, let me know.
We use the same call-in info every time, so.
Good, okay, that makes it easier. Yep. Okay, so now we're gonna just talk about the Public Records Act. Big high overview. It's complicated. Some people, all they do is public records officer responses. It's really important. We have a lot of stuff on our website, both self-serve resources, and topic pages, webinars, workshops, consulting one-on-one. So that's the way to check in, but I'll point out the privacy ones that are included here, and then there's 4 new things in the legislation. But going back to the very beginning, they're called the sunshine laws, this and the OPMA, passed in 1972 by initiative of the people. And sunshine laws, because they shine light on the government. And this slide is from the Clallam County Public Records Officer, and I just love that they included the quote from US Supreme Court Justice Brandeis, who once famously said, "Sunlight is the best of disinfectants." Sunlight, so think of that with open government. And oddly, he said that 3 years before, not oddly, but interestingly, he said that 3 years before he went on this US Supreme Court in 1916. So he said it in 1913, which was also 5 years before the original pandemic in our country, where one of the few treatment things they used was sunlight. They could roll people's hospital beds out in the, outside the hospitals and let them get sunlight to help heal. So I digress. The basic rule, next slide, of the Public Records Act is you must make all public records available for inspection and copying unless there's an exemption. Next slide, what's a public record? Almost everything. There's some case law and there's the RCWs. Next slide, and if you really don't like to go this fast, you like close your eyes for about 5 minutes, but it's just the basics. So any writing containing information relating to the conduct of government, the performance of the government or proprietary function, prepared, owned, used, or retained by the agency. So it doesn't matter that it's not in your possession if you have control over it. For example, a contractor has it or something like that. What is a public record? Next slide. All different kinds, doesn't matter what format, where it's located, or what technology, it can still be a writing. Writing is defined very broadly. Those voicemails, tweets, notes, calendars, all agency-related records on agency devices. Also, some records that might be maintained on personal devices. You want to have a policy maybe to have people not have that be the sole place where a public record is. They can forward it into the agency's records, but it doesn't matter if it's on my cell phone. There's a process where you can have the employee review their own personal records and say, I found these 2 records and nothing else, but I did a reasonable search. That's part of the search. So what is personal and private information that might appear in public records? Lots of things, right? Personal identifying information, medical stuff, mental health information, taxpayer, student records, public assistance, crime victim status, information that reveals things about our private lives that people don't have the right to know. It's not relevant to work for the public agency. So privacy exemption types, the next slide. There's 2 different kinds. There's those that are tailored and specific. There's maybe 4 or 5 of those. And then broadly based on a right to privacy, which is more general. Examples of tailored specific privacy-based exemptions include all applicants for public employment, and these are specific in the Public Records Act. So you'll go through these exemptions. You've probably done it before if you do records for your agency. All public employment applications, my resumes, my application, my cover letter, all those things that I submit. Not anymore now, because I love my job, but all those things are exempt from public disclosure. No one else can say, give me all of the applications of people that applied for this job. Once you're already an employee, then records that are, personal and kept in the files of employees that meet the different requirements, like personal identifying information, my home number, my home email, my date of birth, things like that, have general protection. Adoption records are still confidential in this state. There's a separate RCW for that, and all information submitted as part of a gambling establishment self-exclusion program. That's for people with gambling problems or gambling disorder who want to, in their part of their recovery, make a record so they don't aren't as tempted to relapse maybe. Might not be something that conservation districts deal with, but that's just one example. So can I exempt something based on a person's right to privacy? Yes, but only if there's a specific right that it's based on, and it has to be both an express exemption or one that's recognized by the courts. And you can't just broadly say right to privacy. There has to be a statute that goes with it. So the Public Records Act is interpreted since 1986 to mean there's a personal privacy exemption, but only when disclosure would involve an unreasonable invasion of privacy. After that, 1987, the legislature amended the statute to be clear that, oops, I missed that. There's not an inherent general right to privacy, but agencies having public records should rely only on the express statutory exemptions or constitutional exemptions in refusing to provide public records about privacy. So how to apply that invasion of privacy? There's two parts. That's the next slide. It must be both highly offensive and not of a legitimate concern to the public. So something in a public record about me can be highly offensive, but also of legitimate concern to the public. Say I've taken money or something like that. So then those records are going to probably get disclosed. Question?
So right now, when you're talking about privacy, you're talking about our privacy as people who have that.
Exactly. I'm talking about
Not
our.
necessarily talking about our client privacy, or are you talking about both or right?
It could be, yeah, I'm being a little vague, maybe just to rush with the time, frankly, but the question is, are we talking about the privacy of the public employees or privacy of our customers? And most of these RCWs, although the one about gambling is about obviously any member of the public can obtain that exemption, but I'm talking primarily about privacy of information about public employees that are part of the public records of your agency, because it's sort of maybe more what you're interested in. I'm sure it's also important, the privacy of members of the public, for example, utility customers, their usage day-to-day of electricity, for example, there's an exemption for that. So people don't get to know when they're home, when they're not home. Does that answer the question?
Yeah, thank you.
Thank you for that question. Take a breath. And I'm going to go a little further in here. For Public Records Act rights to privacy exemptions, personal information and files maintained for employees, appointees, or elected officials of any public agency to the extent that disclosure would violate their right to privacy. So that's one that's specific for your officials and your employees. Information required of any taxpayer or collection of tax, when it would violate the right to privacy. Specific intelligence information or investigation records. This is more about law enforcement or jails and corrections. But again, there's always the provision of where the non-disclosure is essential to the protection of a person's right to privacy. Body-worn camera recordings are the other one that's specific. And the agency still needs to engage in that analysis of, would the disclosure both be highly offensive and that there's no legitimate concern to the public? Next slide, internal investigations. If you have one, look at this slide later, or you can call me. Next slide, disclosure must be highly offensive. There are a number of school district cases about this, and that's about whether, so usually they come up in investigations of misconduct, sometimes really bad misconduct, where the victim or survivor is a student. And unless something is completely unfounded, there is an interest in the public to know about that. There's other provisions that let you protect the identity of the victims, but the person that's investigated, those records usually are subject to disclosure. Performance reviews. This is interesting because most standard performance reviews are exempt under a provision in the RCW and a case from 1983. So it's hard squaring how disclosing someone's basic competence in their work is highly offensive, but unsubstantiated allegations of deriving personal gain from agency activities is not highly offensive. But that's what the Dawson case, the distinction the Dawson case made. So until the Supreme Court says otherwise, that's what the law is. This includes reviews of department heads, school principals, but some performance reviews are not exempt from disclosure. And this could be like the agency's chief executive officer, such as a city manager that runs the whole city. And the courts have held that that is of interest to the public and not exempt. What about constitutional rights to privacy? Okay, that would be perhaps, let's see. There's one example of that where with photographs, I think, yeah, it's an unpublished appeals court case here called Lee versus Seattle, and that involved some film photography the Seattle Police Department developed many years after Kurt Cobain's death from Nirvana, I think. And so the family members, the surviving family members, Courtney Love and her daughter, protested those being released to the public, I think maybe the media. And the court held that that right to privacy extends to disclosure of death scene photos, whether it's someone, a celebrity or not. And there's no public interest in those. So they weren't disclosed. It probably shouldn't have been developed either, but that's the police's policy. I think they found some film and thought, let's develop it. Okay, protecting private information during requests that you can do with staff training. There's a procedure to give third-party notice to those involved, and other advice on that. Personal notes. Personal notes, if you make notes just for your own education, you don't share them with anyone else. You don't use them to make a decision later. Those stay personal. It's not a public record. It also has a very short retention schedule. You can, delete them or throw them away as soon as you don't need them anymore. So that's what this case is about. If they're created just for your own convenience or a board member's convenience. And let's go to the next slides after Public Records Act. There's emails on personal accounts. We'll skip ahead, union related emails too, if it's just about the union activities. Those are not public records, even if you used your agency's email. There's 5 steps in a public records response, but I'm not going to go through any of those. This is what's new. I probably should have led with that in the PRA section, but next time. There's 4 new laws. One is regarding audio recordings of school district board meetings only, require about requests for those. There's another one that adds exemptions for personal information of students. There's another new law that amends and renumbers a lot of the exemptions that adds benefit enrollment information. When we fill out, maybe we change to Kaiser or change back or something for our healthcare insurance. That's now expressly protected. I think it was already protected, but there was an argument. And then lastly, the identity of whistleblowers, information about the identity of whistleblowers to other financial and insurance, that was added to other financial and insurance related exemptions. There's state law for training. You probably all know about that. Within 90 days of being on a board, you have to take both the OPMA and PRA training. This refresher, I think, counts for that. We also have free online, the Attorney General's office has free online training where you can get that training or have your supervisors get that training. Then you get a refresher every 4 years. Sometimes things are different, but it's good to do that, at least at the minimum required in the law. We have a page of resources, AG's office, us, WAPRO, the state archivist, Municipal Clerks Association. All of this is specific to open government. And then the next slide is cool. The Attorney General's office, Morgan Damerow and Lucy Collins there, or Collis has a program where they will provide one-on-one assistance for your open government questions. So email them, call them. You can see that on the AG website for open government. Now let's take just a little bit more talking about ethical and effectiveness in financial matters and accountability to the public. And at least one person here does finance. Who else does your agency's finances? Okay, so we can do more of this another day, but I have a few slides here about this. So gifts of public funds and financial accountability. The state constitution is where the doctrine of gift of public funds or resources comes from. You're not allowed to give private entities or private persons public resources, public funds. It started way, way back with the private railroads that were trying to shop around where the railroad's going to go in our state and other states and who's going to give us the most money. So gift of public funds is well rooted in the Constitution. And there's an exception for resources for the poor and infirm. That's been interpreted to mean the poor or infirm. And this includes programs for unhoused persons, discounts for low-income customers, public utilities, persons with disabilities. So the kinds of issues you have with gift of public funds, next slide, are sponsoring youth athletic teams or EV charging stations, donating surplus property to a private entity, retirement gifts, condolence gifts for someone or someone's family, purchasing a table at a charity dinner, an auction, rental or use of conference rooms and other public facilities. Those all might bring into play the gift of public funds or resources prohibition in the Constitution. 3-part test. And if you want to drill down in any of those, we have a lot of resources on our website or call me. The first part is, does it meet the exception for the poor and infirm? That can mean poor or infirm, so low income persons or persons with illnesses or disabilities. If not, then there's the fundamental government purpose. What are the reasons for the expenditure? And for conservation districts, it's all about, the health and welfare and, of the resources, all the land, private and public, and of our state. And so there is a lot of fundamental government purpose in, I think, all the things that you all do, working with the landowners and farm plans and forest practices and those things. So the expenditures do need to have the fundamental government purpose or purposes. You document it when your board makes the decisions. Sometimes it's in the whereases of the resolution. And you save it because at the time of an audit, the state auditor's office might want to see it. Also, is there a donative intent or adequate consideration? So who decides, just because there's a private benefit, it's considered incidental to the public funds. A county relocated a whole tow company business because of floods, and that was not giving the business public funds because it was served the public interest of the county to have the business in a place where it wasn't underwater. Eating and drinking at public expense. This is just a fun reference that I added, providing meals. It's an older 1987 Attorney General's Office letter opinion about how to handle lunches or dinners with your meetings or I don't know, the expenditures you have to be here or to do other parts of your work and how to make sure they're related to the government. And I'm almost out of time. This next slide, financial accountability, is super important because this is the RCW that requires, it's about the role of the state auditor's office, but it requires anyone at a state agency or local government to immediately report to the state auditor's office. So shall immediately report known or suspected loss of public funds or assets or other illegal activity. So not just what you know or what's a fact or what you investigated and decided, oh yeah, that's a loss, it's suspected too. So you have to report it, and the state auditor must adopt policies as necessary to implement this section. So that obligation kicks in right when you know or suspect something. It brings them into the loop. I suppose it might be whistleblowing depending on the circumstances, but it's really important for you to have the state partnership or oversight in the financial things that you do in your agency. So just one slide for that, but that's what I put in there. And then circling back, I want to loop back to where we started with ethical and effective characteristics. As persons in public service, we want to stay true to our values and our commitments and to keep doing the right thing, keep learning, stay on the journey. And this is the importance of the work. Work closely with your agency's legal counsel. The next slide, and almost the last slide. They are an essential part of your team, especially with ethics, open government, and finance matters. And then stay up to date. You can sign up for our newsletters. They come once a week if you're interested. And thank you. I have, less than a minute for questions, but we did get some during the presentation. So thank you very much. I'm happy to be here, and you can ask questions at the break. I'll be here.